Ready?
Yeah.
Yeah, we can share.
Testing. Hi. I'd like to call this meeting to order, July 11th, 2012 Sunshine Ordinance Task Force meeting. 4:30. The 4:30, even though it is 4:35. Yes, we're going to start at the beginning. Madam Clerk, will you do the roll call, please?
Member Nee,
Here.
Member Grant, Member Grant,
Here.
Member Monet,
Present.
Member Washburn,
Here.
Member Pell,
Present.
Member Sims,
Here.
Member David,
Here.
Member Highland, Member Fisher.
Here.
We have a quorum.
Next, we want to go over any agenda changes.
Madam Chair, it's customary to ask at this time if we have received any communications from the absentees regarding the reasons for their absence.
Okay. I have not received any communication. Member Highland is probably just late,
Okay.
and that's it. And then Angela's.
I have not received any communication either.
And we might want to note, since the last meeting, Member West has resigned. Correct?
Correct. Seat 11 was Member West's seat. That is listed here as vacant.
Next meeting. Okay, so the next thing on the agenda is any agenda changes. The first thing I wanted to bring up is item number 11, file number 12. Let me get my glasses. Complaint, file number 12005. The respondent has requested a continuance until the task force is compliant with Section 6730 of the Sunshine Ordinance. So I have a letter here. I have a letter here from the respondent. Other than that, I would like to move that we make a motion that we move items 4 through 7 before item number 2.
Sorry.
This is on the first agenda, before number 2, determining compliance.
Madam Chair? Oh, I'm sorry. Has there been a second?
Second.
Yes, there has been a motion.
I made a motion.
Madam Chair?
Yes.
I have a problem with moving items 6 and 7 to the before item 2, before item 3 has been resolved. On item 5, that usually comes at 5 p.m. or as shortly thereafter as possible. I'm just curious to know why that would be moved.
Well, today I just wanted to move it because those are more procedural things. We will do those rather than item number 2 is going to be a big substantive
Well,
discussion.
but there may be, particularly on item 5, general public comment. There are members of the public many members of the public who come to our meetings regularly. And if they come here expecting to be able to take part in public comment at 5 o'clock, and we've already done it, I don't think that's fair to them. So
Well, we won't have done that because remember this. I'm going to adjourn this agenda, and we're going to go to the special agenda and go to recess this agenda and then go to the one where we are going to go over the election.
Okay, Madam Chair, in that case, I would like to separate items 4 and 5 from 6 and 7.
Okay. So what are you suggesting? 4 and 5 you are agreeable to moving up?
No.
Okay.
Actually, no. 4 I'm agreeable to moving up, although that's not a
Yeah.
that's not a vote. That's not a
Yeah.
vote member. That's just an announcement. Sections 5 through 7, I have a problem with, and I would like to see those items separated.
Okay. So you would like to leave them as is? I'm sorry. I just want to make sure I understand.
Well,
what you're saying.
we have a motion on the floor. I would like to separate that motion. I would like to separate
Got it.
items 5, 6, and 7 out of that motion, vote on them separately.
Got it. Okay, understood. Do we have a second?
That does not
I don't
require a
believe-
second.
Right, it's dividing the question.
I'm fine with that. So I have a motion on the floor right now to move item number 4 before number 2 on the 4:30 agenda. Is there any discussion? May I have a second?
Second.
May I get a vote? Oh,
Public comment is not necessary on procedural matters.
procedural.
It is a procedural question. It's a question of the order of our agenda. Member Threet,
that-
perhaps you would like to weigh in? I'm sorry, Mr. Threet.
Through the chair, it is a procedural matter. It does not require public comment, but public comment may be taken at the discretion of the chair.
Great. Thank you. I won't take public comment on this matter right now. We can move through it. Madam Clerk, do I just take a vote? I don't want to do a roll call. Is everyone in agreement with this, of moving item number 4? Yes?
Then without objection.
Without objection, the motion has passed that item number 4, selection of members, will move on the agenda before item number 2. I'd like to go back to item number 5 and make a motion that we move public comment up under number 4.
Excuse me, Madam Chair. Originally, the motion was to move 4 items before item 2. Member Nee moved to divide the question and have 4 taken separately from 5, 6, and 7. There's already been a motion and a second. So since the question was divided, all that remains is to take the vote on 5, 6, and 7.
So I just need to do them individually?
No, the motion was not made for them individually. It was made to move
To separate 4
all
from
of them
5, 6,
before.
and 7.
Yes, and the dividing the question meant that you took 4 separately, and now you have 5, 6, and 7 to take as a group, because that's the way the motion was made.
Okay,
So that's the vote at this point.
okay.
Madam Chair,
Yes,
I would suggest that we leave the 4 before 2 as we just agreed to, and leave 5, 6, and 7 as is, and either table the motion or withdraw the motion. Just leave it. I suspect that we will get to item 5 after 5, no matter what we do.
so that was my whole point, is to try to get it to 5 o'clock, get it to close to 5 so that we kind of are in.
I suspect that we will. So if you want to withdraw it, or I would move to table.
No, I'll withdraw the motion.
Okay.
That's fine.
If the second withdraws.
Was seconded by Member Fisher.
I'll withdraw.
Great. So right now, we have the agenda changes. Item number 4 moves up, and everything else stays as is. The motion was withdrawn.
So now we're 1, 4, and then everything else.
2, 3,
Okay.
5,
5, 6. Okay.
6, 7,
Thank you.
8. Okay.
On the requested continuance on item 11, do we need to vote on that? Do we need to ask if the respondent is present?
Through the chair, you should ask if the respondent's present and whether they have any comment on that. But the task force is still free to manage its agenda and move the item, even if they're not present.
Madam Chair?
Yes.
I
Member Nate?
believe Member Monet had her hand up first.
Oh,
Question, but it was for point of clarification. Chair Grant, you read a letter of request and continuance from the respondent, correct?
Yes.
Not the complainant.
No, it's from the complainant, I'm sorry.
It's from the complainant.
Yes.
Okay, perhaps we should inquire if anyone representing the respondent is here, and if they have any comments on that.
Is anyone here from case file number 12005, so that would be the MTA? If not, want to continue the discussion, or are you?
That was my only
I
question.
have the letter here from the complainant, so I can read it. Are you guys fine with
Can't we just
moving
wait
forward?
till 11?
Continue.
Shouldn't we just do that?
No,
in
because
order?
because they've asked to continue this until we are in compliance with 6730.
I understand, thank you.
Through the chair, I'd just like to let you know that the complainant
on?
also notified the respondent, so the respondent is aware.
Microphone, please.
Hello?
Yeah.
Okay.
You're on now.
Okay. Sorry, that the complainant also the respondent in 12005 was also notified.
Oh,
that-
okay. So he knew that he, okay. Great. So
So
we need to, I make a motion that we continue item number 11 until such date that we are compliant according with 6730 of the Sunshine Ordinance.
I second that.
Any discussion?
could I suggest that we make it to the call of the chair so that you can determine
The date?
when to put it on?
Sure. So I will withdraw that motion, and I will have a new motion that we continue file number 12005 until the call of the chair. Can I get a second?
I second that motion.
No discussion?
Madam Chair,
Yes. Mr.
this goes back to discussion that took place at our previous meeting, which we wound up adjourning without taking any action on anything except election of officers. I have been in communication with a number of attorneys who specialize in sunshine law, and a couple of them, Terry Frank and Stephen LeBlanc, have opined briefly that we are not in violation, that in spite of, notwithstanding, and I did send them the actual language of the, of 67.30. And what I got back, if I can find it, Terry Frank is General Counsel of the California of Californians Aware, and Mr. Frank also wrote the initial language of the original Sunshine Ordinance, which was enacted by City Hall in 1993. Stephen LeBlanc helped draft the current version of the ordinance, which the voters passed as Proposition G in 1999. And both of them are of the opinion that the absence of a member with a disability does not necessarily disqualify the task force from acting on its from conducting its business. We have, as long as the notice is out there that a member is that members are sought, we are within our legal bounds to move forward. And for that reason, I will vote no on the motion to continue.
Any more discussion? Is this the time? I don't have a second. Can I get public comment now then, please? And so that, I'm going to ask so that we can kind of keep this a little bit brief. 2 minutes, please.
Thank you, Chair. I have to respectfully disagree with Member Nee. I'm not sure that notice is out there of any vacancies. They're only posting on the SF.gov website for sunshine vacancies were for the ones that have already been filled. So the disabled seat, there is no new notice out there on sfgov.org. In addition, Mr. Threet weighed in on June 6th with his advice that you would be out of compliance with 6730 and that you should not conduct further business. So rather than relying on the two lawyers that Mr. Nee, Member Nee, mentioned, I think you should rely on the advice, however reluctant I am to give credence to Mr. Threet. I think you should rely on his guidance because he's the one, theoretically, giving you San Francisco's city attorney's opinion, not Mr. Frankie's and not the other gentleman. So I am speaking in favor of this motion that you do not conduct any further business whatsoever until you are in compliance with 6730. After all, you would not have collaboratively with whatever dress code agreed on June 6th to adjourn your meeting without conducting further business unless you had believed at that time, and you should still believe, that you are out of compliance with 6730.
Thank you.
Good day, members. My name, unfortunately, is Jason Grant-Gars, and I've been before this august, robust committee for over 10 years now. And basically, I'm a little perplexed. You know, I had a case recently, 11081.
Excuse me, sir. Are we referring to the motion that is on the floor
Yes,
right now?
we are.
Okay.
Because Mr. Nee said that he'd spoken with some outside attorneys and gotten some advice. And I had a particular issue that the city attorney had weighed in on, and the Department of Public Health's expert testimony had come up for a HIPAA issue that to this day, I still have not received the items requested through that IDR, case 11081. Now, everyone bent over backwards to allow the shenanigans of what the city attorney said and the DPH city attorney, and I warned the chair at that time that if I was proven correct, what would happen, there was laughter on the tape. Specifically,
Excuse
Mr.
me,
Nee.
sir. I'm gonna interrupt you because we are going to have a moment for public comment.
This is not public comment. This is toward this. Please do not interrupt.
But this
Mr.
doesn't
Nee
have anything-
specifically
I'm sorry,
got
sir.
attorney advice.
Sir. Thank you. Thanks. Next, please.
Members of the task force, Ray Hartz, Director, San Francisco Open Government, and I have to say you're getting off to a really, really bad start. We have spent the last 20 minutes rearranging the agenda. And there is a 4:35 meeting that is here. When are we going to get to that? And the very honestly, the issue before you right now is a question of fairness. Technically, you may legally be entitled to do what you're going to do, but the question is, if a disabled member is not on the board, what is their opportunity to run for the offices of chair or vice chair? What is there an opportunity for a disabled member to be a head of a committee or subcommittee? None. You're basically just saying to all the disabled people, your presence you being absent really doesn't matter to us in the election of officers or the making of assignments. And I think that is the moral imperative. There is a reason that a disabled person is supposed to be on this task force. Two reasons in my mind. One is so that a person who is disabled who comes before this will have someone on the task force who is familiar with their kind of situation. And the second is so that there is a representative of a disabled community on the task force and is able to participate fully. And that includes being up for consideration for election to an official position or as a chair of a committee. And that is not to say that just because someone might be new to the task force, they might not also be a disabled person with previous experience who might make a very, very good committee chair. And so really what I saw the last time was your acknowledgement that not having the person was a problem. I have seen nothing to indicate that anybody on this task force has done anything to rectify that problem between the last meeting and this one. And I think it would really be a dishonest and disingenuous idea to say, well, we admitted we had a problem last time, we did nothing about it, and now we're just going to ignore the fact that we have still the same problem and we're just going to continue.
Personally, I think all this discussion should wait for the agenda item that deals with this issue, if we get to it, if you get to it. But I just want to read you what the ordinance says. I'm sure you're all very familiar with the Sunshine Ordinance. It says, at all times, the task force shall include at least one member who shall be a member of the public who is physically handicapped and who has demonstrated interest in citizen access and participation in local government at all times. And if there's another way to understand that, like sometimes or maybe never, I'd like to hear it. Thank you.
Yeah.
Madam Chair?
Yes.
Respectfully, through the chair, I would like to ask that members of the audience please be seated and be silent, unless they are before the microphone.
Thank you.
Good afternoon, members. I'm Peter Warfield, Executive Director of Library Users Association. Certainly, I would agree with the previous speakers. It certainly seems that you should determine what your overall policy is about holding a meeting when you don't have the composition that is required of you in very certain language. I'd also like to say that I very much object to a restriction on time for the members of the public to comment. The law is clear, up to 3 minutes, and for it to mean anything, it means up to 3 minutes at the speaker's choice, unless there's some very pressing matter at
Sir,
hand.
I'm sorry. It's at
I'd
the
like to
chair's
finish,
choice.
please.
I will let you. You'll get your time back at the end, but just to clarify, it is at the chair's choice, up to 3 minutes. And so I was trying to be respectful of all the members here and give everyone the opportunity to talk to get to the issues that are substantive. So thank you, and continue, please.
Well, then maybe it needs a test case, but the law is meaningless if it gives the chair the option to shrink the time at will. The other concern that I have is the consultation of outside attorneys and the bringing in of those presumed opinions into the room at the very last moment and not in writing and with no documentation. While I appreciate the resourcefulness and what I take to be the intent of Member Nee, for the body and the public not to see very exactly what was asked and very exactly what was said and very exactly what context was provided is to put everybody in a difficult position. And in fact, Member Nee there's been a previous problem with this before, and so I would ask very much that any supposed opinions from outside be brought at least in writing to the body. Thank you.
Thank you. Are there any more public comments?
Derek Kerr. At the last meeting, Supervisor David Campos indicated to the task force that you were out of compliance with the ordinance by not having a disabled member. Member Nee mentioned that there'd been some public notice looking for a disabled member. I'm not aware of that public notice other than the one that was sent to the professional organizations or the media organizations. And the problem with those groups is that they're a very small pool of people compared to the very large pool of the general public. So by notifying this small pool, you're really creating a barrier to disabled people in the general public who would have to be members of these small organizations and who'd have to have the time to join. So this meeting seems illegitimate to me. Thank you.
If I can make a comment. I'm going to comment on the last three. You'll be up soon, sir. On the last three, particularly Mr. Hartz. We're kind of in agreement with you. I mean, everybody around this table right here, we cannot physically or legally go out and pick another member. And we had to wait for the resignation. The resignation just occurred. The goal is to put it on the vacancy list. We are not the Rules Committee. This has to go in front of the Rules Committee. We have lobbied the various people in City Hall to say, help us out here. Find somebody in the comment that was made about this larger pool. So I have to say, we're with you on this. And I'm sorry I'm going to do this. I'm going to stick up for my chair, Grant, here, because we have spoken about this. I mean, you only see us here for a few hours, but the work that we do goes on the entire month. We have spoken at length about this issue, and that is our primary goal at this point, to fill this position. I don't know.
I think you may respond, but may he speak first? You, in the leather jacket. I'm sorry,
Sorry, sir. We didn't get your name.
I don't know your name.
And I cut you off. Sorry, sir.
Hi, Kimo Crossman. As Mr. Grossman indicated, at all times seems to be pretty clear to me. I don't think this task force can continue meeting until this issue is resolved. Maybe the chair should write a letter to Rules if they haven't, to indicate it. And I also want to say that I'm a little concerned to hear that you guys are having discussions outside of the task force meetings about this issue, because that could
Silence
be
in the
a
audience,
sunshine
please.
Violation. If a quorum in some way discusses it with outside the confines of City Hall, that would be not good and a violation of sunshine.
This one.
With all due respect to the member, I really think that saying we're with you on this, but we're going to do it anyway, is really kind of disingenuous. The Board of Supervisors...
Order, please.
The Board of Supervisors had a responsibility to ensure that a disabled member replaced the member that they were in such a hurry to get rid of, and they didn't. And it was their action, their decision to take a qualified member who was up for reappointment and replace him with an unqualified member. That's exactly what they did. And at the moment they did that, they made your body illegally constituted. And the fact that you really don't find it convenient to deal with the issue and want to simply go on for whatever indeterminate length of time it takes to get somebody is really inexcusable. You're basically just saying, we're just going to go without a disabled member on here, and whatever the results might be, however long it might take them, it's up to them and it's not our responsibility. You're the folks that are supposed to be enforcing the rules on every other board and commission in this city. If you can't follow your own rules, then you can't have any reliability or respectability in asking any other city body or commission to do so.
If there are no further public comments, Mr. Nee?
Yeah.
Member Nee?
It seems to me that if we're going to find that we have no business conducting business because we are in violation of the of Section 67.30A, then why single out the item that's before us? I will offer a substitute motion that we adjourn this meeting immediately because we are not in compliance with 67.30A. Silence, please. Is there a
second?
I second.
Mr. Threet, I have a comment.
Through the chair, although certainly a motion such as that is in order for the agenda item that takes up that subject, I don't believe it's in order on this item, which is about continuing a single agenda item at the request of the complainant.
Exactly. So I believe we need to go back to that item because as we saw, this item was up. That was my whole point in putting up, just to let everyone know, of putting the procedural things up to really have a big conversation about this 6730. To get, so you, while you guys are, thinking what we're going to say, you don't know yet because we haven't had the opportunity to speak to it because it is on agenda item to see where we fall in this line of thought. So I would like to, if we could, go through this, make a vote on this, go through the order of the agenda and get to that item as it is on there, and then really come up to some kind of conclusion with the members of the committee. I know there is a second on the floor for the motion to adjourn the meeting, but that needs to be, it's not correct. So can we withdraw it or?
Madam Chair?
Oh, yes, I'm sorry.
Could I suggest procedurally that the motion to adjourn, I think, was properly made, but I think it could be held, and I would suggest that we dispose of the other motion, here item 2, and following the discussion on item 2, take up the vote on the motion to adjourn. It would seem that that makes sense under the circumstances, and I would suggest that to you as the chair. Member Nee? Thanks.
Well, the motion that the chair made was simply to continue item number 11, was it?
Yes, item number 11. File number, item number 11, file 12005. That's the current motion that was on at the request of the complainant.
Madam Chair, may I speak? It seems like if we're not in compliance, we really can't rule on that either. So maybe we need to go straight to number 2 and just deal with that.
Yes.
Since the request to continue item 11 was from the complainant, although I believe in the main we should dispose of complaints as quickly as possible, consistent with the 45-day rule, et cetera, I think that under these circumstances we can act on the request to continue, that's the pending motion, and then deal with item 2 and proceed. So I would, unless there's further discussion, I would call the question.
If I may, through the chair, the current motion on the floor.
Microphone, please.
I'm sorry. The current motion on the floor is item 11, continue to the call of the chair, seconded by Sims. But Member Nee also made the motion to adjourn, which doesn't have to come in the order of the agenda. So it is valid, his motion, seconded by Member Sims.
Member Highland.
Member Highland.
Sorry, Member Highland.
So item number, just for point of clarification, item number 11, we can continue it because that was seconded. And we can vote on, we can vote on it.
Through the chair, the administrator is also a trained parliamentarian. I'm going to defer to her opinion about the motions that are in order. Generally, a motion to adjourn would take precedence over another motion that's pending on the floor. And the parliamentarian has said that it's in order, so you should take that motion first.
Okay, I'd like to have a point of discussion because I don't want to adjourn the meeting yet because I feel as a task force we want to discuss 6730 because we've learned so much since the last meeting. And you as the public, that's what I'm saying. If we adjourn the meeting, understand why I don't want to adjourn the meeting quite right now without having understood what is next, what action we would like to take for most period number 6730. So.
Through the chair, if the question has been called, then discussion is ended, even if other members wish to have further discussion.
Okay.
I was having a discussion with the parliamentarian. It sounded like someone called the question. I'm not sure that happened. But if the question has been called, then that would be the result. Otherwise, you can certainly have that discussion on the motion to adjourn.
Okay. Is there some discussion on this motion to adjourn?
Yeah, I just think that we have an agendized item at the 4:30 special meeting, where it seems like a more appropriate place to be taking up a much richer discussion on the compliance question. So, I think if we should, in my opinion, let's vote on the adjournment right now. I personally would like to see that voted down so that we can then deal with the question of moving item 11, which is also that I believe we still need to vote on.
Mm-hmm.
And then we can get to the 4:30 special meeting and jump right into the question of whether we are in compliance or not. And at that point, I think a motion for an adjournment may be more appropriate.
Okay.
That's my opinion.
So just for a point of clarification, the motion and it has been seconded to adjourn the meeting. We can do that, but that doesn't mean that we are adjourning it right now because we can go back to item 2. Is that correct?
No, if we adjourn, we adjourn.
So, no. Are we going to have to take that off and resubmit another motion to adjourn the meeting? That's my question.
The motion on the floor is to adjourn. If the task force votes to adjourn, the 4:30 meeting is ended. It's adjourned.
Correct.
You
Well,
still
that's
have the
fine. There's a
4:35
4:35
meeting agendized, and then you would have to take up that agenda. But you cannot, if the meeting is adjourned, you cannot come back to the 4:30 agenda.
So, Madam Chair, I would amend my earlier remarks to say if you're going to rule that the motion to adjourn is in order, then that is a privileged motion, and we should dispose of that first. I would agree with Member David that I hope that motion fails and that we can continue to manage the meeting. If that motion passes, then yes, the 4:30 meeting would end. We'd go to the 4:35 meeting, and that's it. So there's nothing to preclude a later motion to adjourn based on the discussion in item 2 if the motion to adjourn now fails.
Can we take, we've done public comment. Can we take a roll call vote? No, I'm sorry, sir. We're going to take a vote now because
Now, this is substantial. Then you should take public comment on a motion to adjourn.
Motion to adjourn
it's not
is
just procedural.
No, it is procedural. So, Madam Clerk, can we take a vote, please? Roll call vote.
Member Nee?
Aye.
Member Nee, aye. Member Monet?
Aye.
Member Monet, aye. Member Washburn?
Aye.
Member Washburn, aye. Member Pilpel?
No?
Member Pilpel, no. Member Sims?
No.
Member Sims, no. Member David?
No.
Yes, he has.
I'm sorry, Member David?
No.
Member Highland?
Aye.
Member Highland, aye. Member Fisher?
No.
Member Fisher, no. Member Grant?
No.
Grant, no.
5-4 fails.
Your motion fails.
Right. So at this time, I'd like, yes, sir.
Still have the main motion on continuing item 11.
Okay, that's what I was going to say. So on motion number, item number 11, I have a motion on the floor to continue this. It was seconded. Is there any discussion on this now? We did discussion. We did discussion, and we talked about it. So, let's go public comment. So can I take a vote? We did public comment. I'd like to take a vote. Roll call.
The motion to continue item number 11 to the call of the chair. Member Nee?
No.
Member Nee, no. Member Monet?
Aye.
Member Monet, aye. Member Washburn?
Aye.
Member Washburn, aye. Member Pilpel?
Aye.
Member Pilpel, aye. Member Sims?
Aye.
Member Sims, aye. Member David?
Aye.
Member David, aye. Member Highland?
Aye.
Member Highland, aye. Member Fisher?
Aye.
Member Fisher, aye. Member Grant?
Aye.
Oh, you go after me.
You have 8 ayes and 1 no.
Okay. And we had already agreed to move item number 4 up to before number 2. So at this...
Point of order, Madam Chair. It is now past 5 o'clock. I believe item 5 would be in order.
Say it again?
It is now past 5 o'clock. I believe item 5 would be in order.
Right.
General public comment.
No more agenda changes.
Put it back the way it was.
So let's go, just as a point of procedure, since we have another, the other agenda, that was the second agenda, can I move the public comment since it is a special meeting? Excuse me, sir, please. Since it's a special meeting, do I need to go to the second agenda to be in order, or can I just go directly to public comment? I know that at 5 o'clock we say we're trying to do that, but as a special meeting that started 30 minutes later than a normal meeting, I assume that we might get 30 minutes more and we'd be closer to 5:30.
To the chair, I believe you should take the item 5, the public comment. It specifies notice to the public that it take place at 5 p.m. as soon thereafter as possible. So it's in order to take that first.
Okay. So there's no vote. I can just take it then. Great.
I'm Patrick Manette Shaw, Chair Grant, members. Some of you may have read Zen in the Art of Motorcycle Maintenance back during the 70s. You've just thrown sand in the eyes of the bull. You have just alienated the entire disabled community by not adjourning. You had no business meeting, and you should not have passed that motion to not adjourn. It's insulting to members of the disabled community that you're even proceeding. That you adjourned last time under august advice from Mr. Threet, and yet you're going to continue this meeting without adjourning. Sounds like you're throwing sand in the eyes of Mr. Threet. You have no business discussing any of this stuff until you are in compliance with not your bylaws, but with the Sunshine Ordinance. It's the ordinance that specifies at all times you are supposed to have a disabled member. It doesn't mean sometimes at your discretion. You can plow right ahead out of compliance, and at other times when it suits your purposes or your private personal agendas, that you can go ahead and continue a meeting that is clearly illegal. You're violating the Sunshine Ordinance, which was passed by the voters. So you're taking that bucket of sand and throwing it in the eyes of the voters as well. Do you really presume as a body of 1, 2, 3, 4, 5, 6, 7, 8 to tell all of San Francisco's electorate that they can take their ordinance and shove it?
Wait, 2 minutes or 3 minutes?
How much time was just given to? 2 minutes, sir.
Okay, since this is general public comment, I'll say number one is that the only body that I have seen so far that limits public comment in common practice is the Board of Supervisors. And my real feeling is that they just don't really give a damn about public comment, and they're going to do it for 2 minutes so that everybody else can do it for 2 minutes. And I think what you're doing is inexcusable. If anybody should stick to the 3 minutes and give people the maximum amount of time to petition government for redress of grievances, it should be this body, period. Secondly, you can't conveniently just say, well, I don't like the way the law is, I want to do something else, and so we're just going to ignore that and do this or that or the other thing. You are required to follow the old adage, pure as Caesar's wife, which means Caesar was the dictator. And Caesar had to do everything, and in fact, his whole family, including his wife, had to do everything by the letter of the law. Because if they didn't do it by the letter of the law, sure enough, the next case you get that involves these issues, someone will come before you and say, why do you tell us we have to do it? You didn't do it. That's the whole problem here. The requirement is there shall at all times be a member of the disabled community on here. I've already spoken to the fact that you're precluding them from being in leadership positions. You're even precluding them from voting on the leadership positions. In other words, you are denying them under the Americans with Disabilities Act for any representation to any actions you take while they're not on the board. And that's a violation of the ADA. I taught that for the United States Navy, so I know whereof I speak. So if you want an ADA complaint with the federal government on your neck, then I would suggest you go ahead and ignore the law, ignore the Sunshine Ordinance, which is what you're here to enforce, and continue.
Thank you. Any more public speakers?
With all due respect, you have 5 members who, up until they applied, I believe only one of you attended a Sunshine Ordinance Task Force meeting. Another one of you did before the hearing before the Rules Committee and complained about the length of the meeting. So this one's only gone an hour, and you're still arguing about agenda items. But there's a conceit involved on your part, these 5 new members, because instead of listening and understanding more about how the task force worked from the 3 people that are still here from previous incarnations, you want to do it your own way. And that's not the way to do it. You should try to learn. But my guess is you haven't even taken the training course, if I had to guess. But this issue of whether you're a legally constituted body is serious, because you shouldn't even be here holding meetings until that seat is filled. Otherwise, you are not fulfilling the basic requirement of the task force. You're already 2 people short, and there's a lot of business that has to be conducted properly. And it's very important to all these people that are sitting back here waiting for their complaints to be heard, because they are supposed to be hearing within 45 days from the time they filed. Section 6721E. So you're going to postpone one of them to the call of the chair. When will that be? That doesn't exist in the task force. It never has.
Thank you, sir.
And
Thank
I
you.
didn't hear a bell.
That was the bell.
Well, then there's something wrong with my hearing aids. The point is,
Okay.
you should learn a bit.
Thank you.
Hello. Once again, my name is Jason Grant Garza, and I only have 2 minutes to say things, and I will say them very quickly. If you go to my own private Guantanamo.com, you will see paperwork from the task force to the Ethics Commission regarding official misconduct. 10 years ago in 2002, where Doug Compton basically said he was sick and tired of the Sunshine Commission getting mooned, and I said, well, you guys are worthless because you're not accomplishing anything, because ethics kicks you down and doesn't do anything. And at the bottom of this particular article that was published in the Bay Guardian, Mr. Nee was going to be on the Rules and Compliance Committee for 10 years ago to get this issue resolved. Now, does the term hypocrite mean anything to you in Sunshine? This is Sunshine. To clean, to disinfect, to make sure that the laws are being followed. Not may be followed, shall be followed. I'm also a person with an ADA problem, and I have written about my ADA issues in front of this and never received a response, because naturally the procedure is rigged. So please do me the favor, because I wanted to bring all these matters up to the new prospective members so that they would become informed as to what has happened in the past, the knowledgeable people not showing up, the ethics kicking this stuff down, my Orange Jude Amendment saying step aside until you're granted power, like the article in the Bay Guardian about Connecticut's Sunshine that works for 30 years because they have enforcement power. Does the term hypocrites mean anything to you in Sunshine? Thank you.
Hi, Kimo Crossman. I just want to say that it's been a tradition of the Sunshine Task Force to have a 3-minute long general public comment at least, and typically 3 minutes for almost every item for public comment. And I know a lot of you never attended Sunshine Task Force before you applied to be on it, so maybe that's why it wasn't 3 minutes. But I hope that's not a indication of how things are changing with the running the task force, because that would be unfortunate.
Good afternoon. I'm Peter Warfield, Executive Director of Library Users Association, and I have been coming to task force meetings for many, many years, sometimes more frequently and sometimes less frequently. To start out with, I think all of you have been put into a very difficult position through the action of the supervisors in basically having a bloodbath of the predecessor members, and through the position they've put you in with respect to the legality of how you're constituted now, lacking a member who is physically disabled as required by law. However, I think that it's important, as others have mentioned, to pay close attention to those few of you who remain who do have experience. And one of the things that I think is important, to respect the public and to treat the public legally, and that requires 3 minutes. Now, one of the things that has come up here earlier today, and that comes up occasionally, and I'd like to ask a question, and I will wait in silence for an answer, and that is, where is it stated that so-called procedural matters do not require any public comment? I have heard this, and I've heard it accepted by members, but never have heard exactly chapter and verse cited. So I'll wait for an answer for the remaining 20 seconds. Time's almost up. I would very much appreciate that the task force would ask the attorney or anybody else to cite chapter and verse for that rule. Thank you.
Thank you. Any more public comment?
Yeah. The citizens of the city and county of San Francisco have been victimized.
Sir, can you state your name, please?
Excuse me. He may or may not. That's his choice.
The citizens of the city and county of San Francisco have been abused by their government for many years, and I am just hoping that this body will be fair and impartial towards the victims and the citizens of the city and county of San Francisco. It does become quite disturbing that you're going to exclude certain members because of the disabled people. I mean, for I'd say probably about a year or two, there weren't any black people on the board, on this committee. And so what's next? Are we going to exclude white men or women or Asians? So I guess just who's next to be excluded? You're dealing with a lot of issues. Most of you are very...
Excuse me, sir.
Yeah, most of you are very new to Sunshine, so I'm hoping that you'll make the right decisions and read the documentation that's necessary to come to the right decisions by the victims of the city and county of San Francisco.
Thank you. Are there any more public comments? If not, then I will close this portion of the meeting. Madam Clerk, can we go to item number 2? Item number 2.
Item number 2, determine compliance with Sunshine Ordinance Section 6730A.
Item 2. So which is it?
Sorry, this is my fault. So item number 4, selection of members to service on standing committees and appointment of its chairs and vice chairs.
As a procedural matter, there are 3 committees: compliance and amendments, education, outreach and training, and rules. The members that I'm just appointing, I have it. I'm just going to appoint the various members of the task force to the various committees that they were interested in.
Chair Grant?
Oh,
yeah, sorry.
yes.
I would like you to entertain a motion to suspend this item until a later time. I think that, we should jump right into item 2, and then, we can come back to this item if it was appropriate at the time. So I'd like to make a motion to, is it suspend? I don't know what the correct word is, but suspend.
Can I comment on that also?
Yes.
Not until there's a second. There's a motion. Is there a second?
I second.
Discussion? So now, Member Highland?
I believe we've already selected the chair and the vice chair. That's already happened. But in deference to getting a member that is a handicapped member, even if we select committee members now, can we add committee members later? In other words, is there a maximum number? I don't believe there is.
No.
So when that person is elected to this task force, they can join any
the committee that they are
like.
interested in.
Madam Chair?
participating in.
There is a maximum number that can serve on the committee, on a committee. That committee is 5.
Mm-hmm.
Otherwise, more than that, you have a quorum of the full task force.
Yes.
Second, it is always a good idea to keep the number of members of a committee at an odd number in order that you can have majority votes on decisions.
Okay, thank you. But as to your point, we will be able to appoint as when we become in compliance with 6730, we will appoint the member to the committee, one of these committees.
Okay, as long as there's room for every committee for that person, I would say.
Yes. Any other discussion? Oh, that's right, you did the motion.
Yep.
And it's been seconded.
There's a motion on the floor.
Through the chair, just for the information of the members, there's an issue with the sound and the microphones. The microphones are not very sensitive, so unless you're speaking directly into them, they often do not pick up the voice. Just for you to be aware of that.
Thank you. So
the motion on the floor, made by David and seconded by Member Highlands to table item number 2. Defer.
You said table.
Item number 4 until item number 2 is heard. You've had the discussion, so you can put the vote, unless there's objection.
Is there any objection? I'd like to take a vote.
I would prefer to take a vote.
Great.
Member Nee?
No.
Member Nee, no. Member Monet?
No.
Member Monet, no. Member Washburn?
No.
Washburn, no. Member Pilpel?
Yes.
Member Pilpel, yes. Member Sims?
Yes.
Member Sims, yes. Member David?
Yes.
Member David, yes. Member Highland?
Yes.
Member Highland, yes. Member Fisher?
Yes.
Member Fisher, yes. Member Grant?
Yes.
Member Grant, yes. You have 6 ayes and 3 noes.
Great, thank you. So the motion to table item number defer item number 4 until after we deal with item number 2 has passed. Madam Clerk, will you now go to item number 2?
Item number 2, determine compliance with Sunshine Ordinance, Section 6730A.
Madam Chair?
Yes.
First of all, I want to apologize. I had thought that I had, and maybe I didn't, maybe I had asked Ms. Osbury to forward the communications to all of you that I had received from Mr. Frank and Mr. LeBlanc.
Yes, we received them.
Oh, you did receive them?
Yes.
And responded.
On the question of 67.30?
Yes.
Oh, okay. Okay.
Sorry, we did not all receive it.
You know, and it isn't. First of all, it's not my intent here to in any way belittle or disparage any opinion that we have received in this matter so far. Certainly not from Mr. Threed, who works very hard on our behalf. And it's not my intent to flout 67.30 or any other law. My intent here was, and had Mr. Frank and Mr. LeBlanc given an opinion similar to that we have been acting on so far, that has been the basis for our conduct so far, certainly I would have brought that forward as well. You know, my intent here was to broaden the discussion among members of the Sunshine community, make them aware that this is going on, and also to provide members of the task force and members of the public, you know, with some additional opinion, regardless of which way that opinion went.
Thank you, Mr. Nee. Yes.
I assume we're discussing item 2. Is that correct? Is that what we're discussing right now?
Yes, we are on item 2.
Okay, so I do want to thank Member Nee for passing on the information, and I actually think it was fairly consistent with the information that City Attorney Threed has, the advice that he's been giving us, that legally we are able to continue to move on. However, I think that that is not anywhere close to what the spirit of the Sunshine Ordinance states, right? I mean, like, I think we have, legally, we're fine, right? But we're not, personally, I'm not looking for a legal excuse to hear cases, right? I mean, I'm incredibly disappointed with the Board of Supervisors for putting us in this position to not have a member on the task force who makes us compliant. And, you know, I think that there's a lot to be said for that. If the Sunshine Ordinance Task Force is out of compliance and hearing cases, like, you know, how do we then tell other bodies that they have to be in compliance? And so I really think that it breaks kind of the spirit of the Sunshine Ordinance for us to continue on without being in compliance. So legally, I agree, we could do it, we can do it, but I don't think that I don't know if I just want to use it, I want to be careful. Ethically, I have a problem with it. I think in the spirit, I think it totally goes against the spirit of the Sunshine Ordinance Task Force. So at the end of this discussion item, I think it would be appropriate to have a motion to adjourn. But I would like to leave it open to now so other people can state their opinions on that.
Madam Chair.
Yes, Member Washburn.
Yes, I think this brings up a number of interesting issues. First of all, in the plain English reading of 6730, at all times the task force shall include at least one member who shall be a member of the public who is physically handicapped. That seems absolutely clear. But I think one of the attorneys that Member Nee consulted was basing his interpretation in part on the meaning of shall, saying that shall doesn't mean you must, but you could. And I believe that this matter has come up before us and from some of the cases we've looked at, and we have tended to interpret shall to mean must. And, okay, so that's just our precedence. But the other issue here is our charge always to interpret the law, the ordinance, in a way that goes to support open government and support members of the public in redressing matters before us. And so I think if we take that seriously, then in this case, we need to interpret this in the way that's most fair, in the way that most protects members of the public, particularly those who have significant barriers to participation. So for that, for these reasons, I will be voting to adjourn this meeting until we have a member who's physically disabled.
Member Nee?
Yes. I totally agree with the sentiments that members David and Washburn have just given us, have just expressed. I am equally chagrined at the way the Board of Supervisors has conducted itself in this entire matter, particularly certain members who exercised a vendetta in order to keep off of the task force an incumbent applicant who is handicapped and who has a demonstrated interest, an active interest in open government. That member being Bruce Wolf. The task force now, the board now, with member West having resigned, the board again has that opportunity to appoint a handicapped member without pushing off any of the current members of the task force. And perhaps I don't know if this requires a motion, but let me suggest that the chair of the task force send a letter to that effect, reminding the Rules Committee and the Board of Supervisors of what the law, of what 67.30 says, of the fact that because we don't have a handicapped or a disabled member on the task force now, we have determined that it would be best not to proceed with our business, and this is delaying justice, as a matter of fact. One of the reasons that I really would like to see us move forward, even without a disabled member here, is the fact that we have a whole bunch of complaints before us, and justice is being delayed, and therefore justice is being denied. And I don't think that's right. At the same time, there are sunshine issues that members of the disabled community do have. For instance, sight and hearing impaired people. They have special needs when it comes to making sure that they have access to the decisions of government and to the reasons for those decisions. So yes, we absolutely need somebody on the task force. We need that representation from that community of people with disabilities.
Thank you. Just to give you guys a little bit of background, we pretty much are all, in agreement that we need a member of the disabled community. When we read Section 6730 of the ordinance, it's very, in my opinion, the wording is so strong at all times. I believe someone said that earlier. At all times, and that conveys to us, and we are the new members, but when we read that and just simply think we need to have a disabled member on this committee. Member West resigned approximately 1 week ago, so that letter has gone to the Board of Supervisors, so they're fully aware from the last meeting that we did not have, we were not in compliance. So we did not at that meeting cancel this meeting, so that's why we came together to try to figure out what kind of a resolution. We are kind of in a catch-22 right now because just as Member Nee said, there are all these cases that we are enthusiastic, we believe in open government, we're here, we're trying to get ready to do these, but is the bigger issue that we don't have a handicapped member, a disabled member, a community member here. And so we, in thinking about it, for me, it seems that that is the bigger issue right now because we are not in compliance as a task force. So I am going to propose, I'm going to put a motion on the floor that we first and foremost, do you have something to say before I make the motion?
I do have a comment to make.
Okay, so I'm going to let you make my comment and then.
I mean, I've read the Sunshine Ordinance Task Force, the Sunshine Ordinance in section 67.30. And while I thank Mr. Nee for giving us Mr. LeBlanc's and Mr. Frank's legislative history opinion about what their intent was in drafting.
Excuse me, sir. Please respect each speaker in this room, public and on the task force. Thank you.
Like I said, the legislative history as drafters, correct, Mr. Nee, as drafters of the Sunshine Ordinance. However, even with their legislative history, that only comes into play when the language is ambiguous. Here, the letter of the law, the language is not ambiguous. It says clearly at all times, and it doesn't say it anywhere else. And so that makes it even more persuasive that we need a member who is physically handicapped. I do not, with all due respect to Mr. LeBlanc and Mr. Frank, I don't think the terminology shall is really an appropriate issue because shall is used several times, and to take that interpretation would be to believe that the option is available everywhere the word shall is. When it says shall be a local journalist or shall be appointed from the Women's League, and we both all agree here that is an option. And I want to thank the public for their comments and their obviously care and concern about this issue, and I think we all feel that. And I think, however, my issue with is I think my issue is that for those that are truly concerned about Sunshine, you have given the Board of Supervisors a way to destroy Sunshine in a way because, as you said, we cannot move forward without a member of the physically disabled community. So, excuse me, let me finish. I said we, not just by voting and saying that we will not move forward until there's someone who is physically disabled. We are putting it in the hands of the Board of Supervisors. Our hope and our desire is that they move forward. But if they do not move forward, then essentially the Sunshine Ordinance shuts down. It doesn't exist. It's now the 45-day rule we know is being violated and is continually being violated, and that's the problem, and that's the concern, and that's the concern I think everyone on the task force has. And I think that the hope is that they do appoint someone who is physically disabled and physically handicapped, and we can move forward and not being in non-compliance with the 45-day rule. I did, and so my vote will be that we do adjourn because we are not in compliance with the ordinance. And I do want to say that it could be interpreted that even this physically handicapped person could come from the mayor or his designee and the clerk of the Board of Supervisors. And they had that option to, it could be interpreted. It could, Mr. Nee, I'm sure your interpretation is different, but it could be interpreted. I'm not saying that's my belief or my interpretation, but it could be interpreted through the plain language of the ordinance, even though that might not have been someone's legislative intent. And they had that option, but they don't sit here today. So I'm not even going to bring that up since they have failed to provide a member as their designee to the task force. So I would encourage the other members of the task force to adjourn until we find it. And I really hope that the public will be able to get justice done eventually.
Member Pilpel?
Thank you. This is obviously a very difficult and highly charged item. I wanted to ask Deputy City Attorney Threet, you explained at the last meeting your analysis at that time. If I recall in summary that we would be in violation, but a court would likely validate our actions and we could therefore proceed if we chose to, and it was essentially a policy call for us and the body chose not to proceed last month. That's the summary that I recall. I could be slightly off on that if you want to amend that, and then I had a follow-up question.
Through the chair to Member Pilpel, my advice in short was that meeting and taking substantive action without the disabled member would be a violation of 67.30. Although the Board of Supervisors may, carry separate responsibility for not having appointed that the board, this task force would be meeting in violation of that section. And nevertheless, although there is a risk that a court, if an action was challenged, could invalidate the action, I don't believe the risk is high because there is case law in two areas that suggests that the board's action would nevertheless be valid. I could go into that in more detail, but that's the summary of the advice.
And I appreciate that. My follow-up question is, given the change in circumstances in the last month, i.e. that there's a member who has resigned, that there is a vacancy in a general public seat, does that change your current analysis of the situation, or would you advise just as you did then?
Through the chair, it would not change my advice.
So to summarize then, it is a policy call for us, given the risk, however we perceive that risk, whether to proceed.
Through the chair, I think that's a fair summary. I also was remiss last time in not highlighting this issue, and I'll bring it to the fore this time. 6730 is a provision of the Sunshine Ordinance, so to the extent the members of the task force take action in violation of that ordinance, there could be complaints filed against them for those violations.
And just my final question, if I might, on this. In trying to reconcile what I see as somewhat conflicting provisions in 67.21 E and 67.30, where you've got time frames and yet at all times, and then looking to either a rule of necessity or a rule of reason, is there a way to harmonize or reconcile those sections, or is that how you've balanced in your short advice?
Through the chair to Member Pilpel, there is a conflict currently with those two provisions because the 45-day rule is in violation in several cases, in increasing number of cases because of the delays in the task force taking action and adjourning at the last meeting and possibly at this meeting. And that's one of the bases for the rule of necessity that underlied my advice, that the task force nevertheless could take action, and its action would likely be validated if it was challenged later.
Are there any more comments from the task force members? Mr. Nee?
Just briefly, one of the points that it was either Mr. Frank or Mr. LeBlanc made is that although the language says shall, there is no there's no or else. In other words, there is no there's no language in there that says what happens if we do conduct business without a disabled member present on our body. I'm not saying that that will change my vote on this matter, but I just want to throw it out there as food for thought. Maybe even Mr. Threet would like to comment on it or not, but I just want to throw it out there as food for thought.
No, I like to comment on that as well. I mean, I don't see anything how even if we were in non-compliance and we went forward, obviously I think we violated the Sunshine Ordinance by doing that. However, violations of the Sunshine Ordinance go back to the Sunshine Ordinance Task Force. Now, then we would have to all recuse ourselves, and so then the complaint would be dismissed. I'm almost positive. I mean, I'm not an expert yet on Sunshine Task Force, but I am a lawyer, so.
It would get complicated.
Yeah.
More so than it is.
Yes.
Mr. Threet, would you care to comment on Mr. Nee's original?
Through the chair to Member Nee, at the last meeting, that was a separate basis for the advice that I gave, that the task force nevertheless could proceed with taking official action and that would likely be upheld. There were a series of cases that involved violations of the, my memory's failing me, it was either the Public Records Act or the Brown Act, prior to it containing enforcement provisions that specifically said that there could be an enforcement against an official who violated it. And at that time, there were the mandates that said you shall do these specific things to comply with the ordinance. And a case was brought, and the court held that although the language was shall, it was directory rather than mandatory, and that without specific provisions for enforcement of violations, there was no consequence to the violation. So the court that was the decision of the court. Since then, the legislature has amended the statutes to provide those enforcement provisions so that they become mandatory.
Yeah, I'm going to let's try to wrap it up. You can, yes, Mr. Purple.
I'm sorry. Well, that just sort of begged a further question. The 67.30 requirement is strictly in local law, not state law. To the extent that there is no penalty, consequence, or remedy for that sort of violation, does that give rise to an interpretation that it is directory and not mandatory? I mean, that you're making me think here. I appreciate that, by the way.
Through the chair to Member Pilpel, it nevertheless is a violation of the ordinance,
Right.
but that's a different question whether the task force would still be legally able to take action.
Thank you. I think maybe public comment would help.
Well, I'm going to make a motion. I'm going to make a motion first, and then can we take public comment, or do I need to take public comment because we don't have anything on the floor? Yeah, sir, if you could sit down one moment, please. I'd like to make a motion. We've all heard both sides, all the pros and cons. I'm going to go with kind of the way I feel morally about this, and I'd like to make a motion that right now we, as a task force, write a letter to the Board of Supervisors indicating that we don't feel that we can move forward right now because we are in violation of 6730, and that there's no other motion on the floor, and excuse me, I'm talking. I'd like to make that motion that we write a letter to the Board of Supervisors indicating our displeasure and the fact that we are believe that we are in violation of Ordinance 67 Section 6730 of the ordinance, and we will not have any more meetings until we will cancel all meetings until which time a member of the disabled community is appointed to the board.
Second.
Any comment from the task force?
Is there any way we can put a time frame on that?
What would you, yeah.
Because if we don't, we're just handing the Board of Supervisors a reason to do nothing.
Okay.
I'd like to sincerely second those sentiments just now expressed by Member Highland. I think it probably would behoove us to give some kind of time frame so that, we're not just sort of leaving ourselves in limbo.
Then I would like to withdraw that motion.
Second withdraws.
And I'd like to put out a new motion that we would like to write a letter to the Board of Supervisors indicating our belief that we are in violation of Section 6730 of the ordinance, and we will not meet until we would like to have this rectified by the end of, what's the July 11th?
They're going to be in recess in August, so.
Okay. So by the, excuse me.
Could we have the audience silent, please?
Thank you, though. So then we would like to have some sort of restitution, something by July 27th, which is 2 weeks from now.
Is that a Wednesday?
It's a Friday.
No. Let's make it for, I would say 13 days from today. I would say July 24th.
So,
Board of Supervisors meets on Tuesdays.
Great. So Monday, then the 23rd. Is that correct? Tuesday 24th.
Tuesday 24th.
I'm sorry. Yeah, Tuesday, July 24th. Mr. Threet?
Just for point of information, the Rules Committee, I believe, met today at a special meeting. Their regular meetings are the 1st and 3rd.
Yes.
And so the Rules Committee would first have to meet, and then it would have to be referred to the Board of Supervisors. So you might want to take those things into consideration in calculating the times.
Rules Committee Chair is Jane Kim.
Chair Grant. Hi. I don't see any actual advantage to putting a date, right? I mean, I think the letter, I think having a motion to send a letter saying that please provide the Sunshine Task Force with a member that, makes us compliant with 6730, as soon as possible is adequate, right? I mean, because it leaves open the ability for us to meet, right? I mean, kind of as Member Highland said, if we give a date and they don't do it by then, or, and then it can, for all intents and purposes, shut us down. Or if strike that. If we don't give a date and we say we're not going to meet until that point, it just shuts us down, right? And if we, at the end of the day, what we're trying to do is say, hey, we're not happy with this. We'd like to encourage you to, as quickly as possible, find, appoint someone who's qualified in that section. So I think the conversation about the date is I don't see the advantage that it really gives.
Madam Chair?
Yes.
It might be a good idea to point out in the letter that the board does have a role, a definite, specified role and responsibility in this matter, and that the failure of the board to meet that responsibility, to meet its legal obligation, could result in action being sought before the Ethics Commission and/or the California Attorney General and/or the District Attorney.
Member Pilpel?
I was headed there, but not necessarily all the way there. I would agree in general not to include dates in the communication, but to reference that we believe that we would be in violation, which exposes the city to some risk. Similarly, the board has a responsibility to appoint, and by failing to do so consistent with all of 67.30, which might be a way to explicitly or implicitly reference the holdover appointments, that the board further exposes the city to a degree of risk. We would prefer that this situation be resolved as soon as possible. We appreciate your assistance to that end. Something to that effect to the full board, and maybe suggest that you have a conversation with Chair Kim. I think it's going to be I think it would be great, and I think the board ultimately will resolve this, but I think it's going to be difficult for them to do this in the next 13 days, in the next 20 days. You know, in the past, they've had there's a recess that is coming up. They have waited 10 days to fill unscheduled vacancies. I don't know if this is subject to the Maddie Act posting requirement where there's an unscheduled. There's all kinds of crazy stuff that relates to vacancies, and I think even if they move this as expeditiously as possible, it's still going to take some time. And if we say we're not going to meet until, but you know, we want you to be aware, however you choose to express it, I think we can be somewhat vague in the motion, but I think we can convey those thoughts.
Oh, yes, Member Washburn.
Yes, I agree with Member Pilpel that we should do a couple of things with this letter. One, mention the holdover appointments. There's actually one vacancy because of this issue, and two of us are kind of in limbo. So that needs to be resolved. And I also think the letter should include a reminder that we have another part of the ordinance which mandates that we hear cases within 45 days, and if this isn't resolved, we're delaying justice for many people who have already had their complaints delayed. So I think that needs to be hammered home to them.
I'm in full. Oh, I'm sorry.
I was going to say, maybe you can just ask them to please put us in compliance by our next meeting, which is August, first week of August, I believe, August 7th.
Well, I guess the conversation is if we can't meet if we don't have the member, you know, the way we all feel. So that was the whole issue of not putting a date down, because if we don't want to meet. We can't. We're just not in compliance. So we're just wasting time. We're not moving any cases forward. People are here and they've sought justice through the proper channels, legal means, and we aren't doing our part. So for us to put a date, say by the next meeting, if we don't have a disabled member, we'd be out of, we'd be out of order again. So for me, I kind of agree with Member David in that we put forth in the letter all the things that, we are in noncompliance with as far as the holdover members as well, but primarily the handicap member, and reminder about the 45-day issue and that they are delaying justice for us. I'm not going to put it, in my motion, I'm not going to put a date. I'm just going to say as soon as possible and go from there. Did I have a second?
I second.
Second from Member Nee on the original motion.
My second stands. Not a problem.
Okay. Yes, sir.
So, public comment. I'm speaking in favor of this motion. Member Highland, Member Sims, Member David appear to get it. You're in clear violation. The language is not at all ambiguous. It's very precise. I don't know if I could write enough campaign contribution checks to the Board of Supervisors to convince them that it was their error. News has it that we have another lawyer on the Board of Supervisors who hasn't wanted to reveal that she is licensed to practice in the state of California. But that body is comprised of some really smart lawyers. Mr. Wiener, for his part, was trained at Harvard. He should have known that there was no ambiguity in that sentence. He should never have put you in this position where members of the public could perceive that it is you denying and delaying justice. Indeed, it's Mr. Wiener who's done that almost single-handedly by nominating somebody that he favored for a seat on this body by kicking off someone else. And when Ms. Cavillo was here on June 6th, she had no business suggesting that the board was aggressively pursuing finding a disabled member from the 3 nominating agencies, the Society of Professional Journalists, the League of Women Voters, and New American Media. Because Ms. Cavillo, in her long track record as clerk, should have known that that seat is reserved for a member of the public, not for one of those 3 agencies. So they can't just go fishing to find a replacement in a hat and pull out a rabbit that doesn't fit.
Thank you. Any other comment?
Yes, hello. Once again, my name is Jason Grant Garza, and I've been before this committee for over a decade now and have, many orders of determination in my favor and everything else. The really interesting part was that you're going to refer something to the Board of Supervisors. Pardon me. I had a conversation earlier this morning with Angela because I was specifically asking her who was over you guys so that I could file a complaint for an investigation into the lack of your procedures, the 45-day delay, the fact that you get no results at ethics, yada, yada, yada. And I was informed by her that the Board of Supervisors does not take complaints or do investigations. That you guys are your own independent body and that all their office does is provide the clerk. So for you to go to them when they've already, not taken up matters as far as the Ethics Commission, overriding you with official misconduct and everything, once again, let's get real here, folks. This is the Sunshine Task Force. Another thing I'd like to comment on is that, we're talking about members being disabled. Excuse me, Mr. Wolf was not the Disability Task Force representative because I specifically sent in an IDR in December, which still has not been scheduled, asking who was the official disability. He is nothing but a token. He is a disabled person. He is not the official disability representative because in my cases, I've been asking for ADA help and help from the official disability task representative. As a matter of fact, Mr. Wolf conveniently forgot about the HIPAA, thing that's been stretching on, in my case, 11081, which still has not been resolved because of the incorrect city attorney advice, which they've now conceded to. But rather than to bring this matter in front of the full board so that there will be justice, it's just being whitewashed over, but I will continue to do the correct thing in an incorrect system.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I should probably be the one who's saying go forward. I had 3 complaints on last month's agenda, but I understood the importance of having a disabled member on the task force because it's a requirement of the ordinance. I again have 2 on today's, and I guess I would be if self-interest would tell me, oh, go ahead, I don't really care about this disabled issue. But the reality is, look at your agenda for today. You're going to first appoint committee chairs, then you're going to elect a new president and vice president. And what does that say? It's like, oh, we're going to let somebody appoint committee chairs, and then we're going to, just assume that that same person is going to be reelected as chair, and therefore the actions we just took are going to be sustained? Or will somebody else get elected, and they will simply say, well, I don't like who was selected by the prior chair, I want to select a new chair. Then you have a case that's already been continued that we discussed earlier because someone said there isn't anybody who represents the disabled community on the task force, and I want this continued. Nobody is required under ADA or any other legal requirement to identify themselves as a disabled person. However, There is nothing that following precludes them from saying the reason I lost my case was because there was no disabled on and I was not represented on the board, and therefore I find that whatever you did was not lawful. I mean, you know, you're just really going around in circles here. And very honestly, one of the comments that was first made by the first speaker, I do not think that any member of the Board of Supervisors just forgot the requirement. They were just in a hurry to get rid of Mr. Wolf. They didn't really give a damn whether or not that caused a problem for you. In fact, one or two of those members, I really honestly feel, someone has already mentioned, maybe that's exactly what they wanted. And very frankly, I think that, you know, there is really no impetus. What are you going to do if 6 months from now they haven't done anything? What kind of a possible justification are you going to be able to present as month after month after month after month goes by, they do nothing, and you keep hearing and deciding cases? At that point, you will find someone who takes you to court.
Hello, task members. I'm William J. Clark, and I have two items on the calendar tonight, number 12 and number 13. And I just want to make you aware that I have been waiting through several meetings, and I understand the dilemma and the legalities behind this. And I think, like the lawyer said, that there's no ambiguity in this statement, and therefore there's no reason to do anything other than what it appears that you're doing. And I would just like to say to you that as one of the members of the public who has been waiting beyond the 45 days, I understand what it is, but I would appreciate it if you would include my complaint and name in the letter and make the supervisors aware that I don't hold you responsible for any of this, but I do hold the Board of Supervisors responsible. And I don't want to come back here next month and you know, be told again, we've got to wait again. And I also noticed that there's no representative from the Department of the Arts Commission here, and I think that they are the old committee task force members, that they understand what that means, but I believe that they are well aware that if you find in my favor, that they're going to just laugh it off because they're going to argue that you're not in compliance with the law yourselves. And so reluctantly, you know, I would ask that you would adjourn the meeting, and then I'll be back when the next time we do meet legally. Thank you.
Thank you for your comments, sir. There is somebody in the back of the room from the Arts Commission who raised her hand, and I wanted you to be aware of that.
I'll try to be brief. There's no legislative history on the Sunshine Ordinance. It was 5 or more guys working desperately to get it ready. And the one guy who probably could have helped, Doug Comstock, the Rules Committee didn't think was worthwhile. And that's why he's not sitting in one of those seats. In Terry Frank's and the other guy's case, if they have any opinion, I'd like to see it in writing, and I'd like to see it fully thought through, because I've dealt with Mr. Frank and asked him for help on the task force, on the ordinance, and he didn't even bother to return my emails. On actions that you would take when you're not legally constituted, well, it's a willful violation. You get to, a couple of things will happen. Any referrals to the Ethics Commission will be tossed automatically by St. Croix, so it's a idle gesture, and all the departments will know that, so you'll be wasting your time and everybody else's time. And there are enforcement provisions in the Sunshine Ordinance. You look at 6735B and D, both provide for enforcement for violations of the ordinance and fees, which is important because the city will end up having to pay them. And a mandamus case, I'm sure, could be filed and won very quickly. The last thing is, I wondered if you ever thought about the possibility that instead of Bruce Wolf as a disabled person was the one booted, it was actually a minority person, maybe Hanley Chan, who is Chinese American. And what do you think would be happening now? Do you think that David Chu and the other Chinese Americans that are so directly involved, the mayor, would let that seat stand empty? I doubt it. So just think.
Thank you, sir. Appreciate your comments.
Hi, my name is Robert Clark, and just to let the new members know, I am William Clark's twin brother, so I'm not attempting to speak longer than I'm allowed to speak. But I just wanted to let you know that I support what my brother said, and the fact that I don't take this, any of the new members, I don't feel any ill will towards any of you, because this is not of your doing. And I would only ask, I don't know if you're capable of doing it, but in your letter, if it would be possible for you to ask the Board of Supervisors that when they're looking for this disabled member of the public to take a seat here, it's going to be very difficult, because people who are disabled may not have the time or the ability or the interest to be a member of this board. And I think you should possibly include it in your language that after a reasonable amount of time looking for a new member, if the board is unable to find anybody, that there was one person, Mr. Wolf, that was willing to be reinstated to the board, and after a reasonable amount of time, whatever that amount of time is, that if no other person could be found, that this board request that the Board of Supervisors reappoint Mr. Wolf to the task force.
Thank you.
Mr. Clark, thank you for wearing different colored jackets, and as a new member, I appreciate that. And love it if you continue to do that.
Well, I definitely believe that I think y'all should just be kind of like offended, just that the Board of Supervisors would stick you in the middle of these battles, and they're almost like using you as fodder to cover up some of their misdoings and some of the misdoings of the other people in the city and county of San Francisco. So. And now you got this whole other part where they got this disabled person and not allowing him. It's just really, they're kind of like abusing you. And I don't know when they're going to appoint anybody, or if they even have any desire to appoint anybody. But I think that's one of the reasons why that guy resigned, because you're being abused here, and I'm just hoping y'all will stand up to them.
Thank you.
I'm Peter Warfield, Executive Director of Library Users Association. I think all of the comments you've heard have been good and certainly worthy of strong consideration. I said at a previous meeting, the previous meeting, that particularly for the newcomers, many of the people on this side of the podium have had a great deal of experience with Sunshine and with the Sunshine Ordinance Task Force, and are very worthy to be listened to. In that connection, a minor nomenclature point: the people on this side are the public and members of the public. And as members of the public, we have certain rights under the law, and we participate in your deliberations under the law. We are not an audience who sits there passively taking whatever you do for the purpose of entertaining us. With respect to your prospective letter, first of all, I think it's clear that you don't mean to say we are in violation in the sense that you did something wrong. You haven't done anything wrong, and I think you should say that the body as it's constituted is in violation of the law. You haven't done anything wrong with respect to that. I think you should specify the failures that you are building up, which is to say the 45-day requirements for hearings, the promptness issue, Third, you should meet with a note to the public on your agenda that if the supervisors have appointed somebody appropriately in time for the meeting, then you will go ahead with it. But if they haven't, you can't. That's, I think, as with a rent strike or something like that, you put the money in escrow. Likewise, you should meet. Fourth, give them a date so they'll have a specific request for an answer, whether they're on time or late. They'll have something to aim for. Copy the Ethics Commission, the district attorney, the media, and maybe you should file a complaint because the supervisors are in violation of the law, and you should file a complaint with any agency that you think can enforce your rights to have a full and proper complement. Thank you.
Thank you. Are there any more public comments on this issue?
Yes, ma'am. I have a public comment on this issue. My name is Jeremy Miller. I'm co-director of Education on Incarceration in the Edith Stelly Foundation, and I'm also my Sunshine Ordinance complaint is on tonight's calendar as well. It is. Let's see if I can get the list here. It is complaint number 12005, I believe, is the.
Yes.
MTA?
Against the MTA, yes.
Item 11.
Yes.
Okay, so I appreciate the dilemma that you all are in. I want to second what was just said and agree with the chorus of voices that are calling for adjournment until you are clearly in compliance. And the reason is quite simple. Many of these cases, this body is set up specifically to allow for open government, to promote open government. Therefore, many of the cases that will come before this body will be controversial, will be cases that there are other people in city government or city agencies that might not want to see this information come to light, come to public light. And the way that they're going to stop that flow of information is the way they always do, through technicalities. So if there is an obvious glaring failure in terms of technicalities, an obvious glaring loophole whereby they can invalidate decisions that this body makes, it is necessary that loophole be closed. I don't think it's even questionable. And in terms of the 45-day thing, I don't know when exactly the 45 days, I have to go refer back to the ordinance to see exactly when the 45 days starts. But my initial immediate disclosure request was October of last year, and the complaint was January. So we're well past 45 days at this point. We just want to make sure that when this does get heard and decisions are rendered, that we're not going to have to go back to square one or even further back and do a rearguard fight because it's declared invalid.
Thank you so much.
I think I'm the last one. Dr. Maria Rivero here. I wanted to thank all of you for complying with the Sunshine Ordinance. That's such an important thing to be role modeling to everyone else in government that doesn't seem to do that. And I would advocate for putting something in the letter that talks about the fact that the Rules Committee did advance a qualified disabled person to serve on the task force, and that was Bruce Wolf. And it was the Board of Supervisors who said, no, we're going to put someone else in his place. Well, now there's another spot. So Bruce Wolf should be advanced to that position, and you shouldn't meet until that happens. Thank you very much.
You should include that in the letter.
Thank you. Any more comments? If not, Member Pilpel, do you have a comment?
Just one brief thing, thinking about one of the comments that was made. I'm going to have to look in the next month or two at home. I recall in the 1999 discussions on the amendments that Stephen LeBlanc was one of the co-authors. Doug Comstock was part of that. Rick, you and I were part of that. Somewhere, I think I still have a marked or track changes version of the ordinance with the author of each particular section. I'm going to look for that. If I can find that, that might be useful for some of these discussions. But that would be very interesting if I can dig that up.
Madam Chair?
Oh.
Briefly, actually, I believe in the note that Mr. LeBlanc said 2 or 3 days ago, he mentioned that he did not write this specific
Right.
section. So my guess is that would be Thomas Burke.
Would have been. There were. Anyway, if I can find that, it might be a helpful document. But I'm certainly in favor of the motions before us.
Great. If there are no more public comments, I'd like to take a vote on the motion of writing a letter to the Board of Supervisors. Madam Clerk, will you read the motion that is on the floor right now?
I have, if you wanted to add to this, I'm sorry, I have that it was motion made by Member David, seconded by Nee, to write a letter to the Board of Supervisors without a time frame, ASAP, and then to include, if you want to add to that, what exactly you want to add.
I created the motion.
Yes.
I made the motion.
Yeah, no, I did.
Oh, okay, you're right.
I did.
Said
But there
David.
are things that maybe the speakers you wanted to add into the letter.
Say it again.
Were there items that were that the public mentioned that you want to add into the letter? Sorry.
I see. Yes. Member Highland? Yes.
Madam Chair. Perhaps the city attorney can give us some advice on this, but to elevate it to a complaint, what would that involve? Does that give us more ammunition to make it a complaint rather than a letter to the supervisors?
Through the chair to Member Highland, I'm not exactly sure what the question is you're asking. Can you ask me again, please?
Sure. Not being familiar with a complaint versus a letter, the status of each, what would be the implications if we elevated this to a complaint to the supervisors rather than just a letter? And what would you advise on that?
There's no formal administrative complaint process to the Board of Supervisors.
So the letter would serve in the capacity of us
Yes.
complaining. That is the strongest we can do at this point.
The Board of Supervisors is free to investigate complaints. If an individual supervisor would like to create an item for a committee hearing, they may do so, but there's no administrative complaint process at the Board of Supervisors.
Okay, that's what I was asking. Thank you.
Member Pilpel?
Just so we're clear, I think it's actually granting some, I wouldn't say overly broad, but some latitude to you as chair to craft a letter to send. So I don't know that we need to micromanage the text. I think enough direction has been given, and you'll do a fine job, and we'll see copies of it. I would also suggest that we specifically CC the Ethics Commission because they are waiting to send stuff to us. I'm not swayed one way or the other about notifying anybody else, but I think a copy to the Ethics Commission would be in order. I'm not averse to CCing the mayor or the city attorney formally.
Are we all in agreement who we want to make sure this letter is, besides the Board of Supervisors, who we'd like this letter to be seen by here in City Hall? The Ethics Commission? Anyone else? Mayor? City Attorney?
It was mentioned, sorry, if I may, it was mentioned that it also be sent to members of the media, and I would actually support that very strongly, just so that it is known the situation that we are in as advocates for open government, unfortunately being put in this limbo.
Madam Chair, I would respectfully request that the chair silence members of the audience. Members of the public gallery.
Yes. Sir. Noted. Thank you, sir. I'm sorry, who else? Okay. I think that, yes.
In the interest of clarification, I thought I had heard at one point that there was some context around adjournment, whether it was going to be for this meeting or continuing until the board takes action. It's unclear. Perhaps I missed that. I'm just,
We wanted to adjourn this meeting, in my understanding, after we dealt with issue 6730, which we're dealing with this letter.
I mean, in the motion itself, is the motion simply to send a letter, or does it also include that the meeting be adjourned?
These were two separate motions.
Yes. Okay, thank you.
This is this motion, and then we had to adjourn the meeting. So, Madam Clerk, can you continue just what the motion is on the table, and then we can take a vote?
Well, the motion on the table is for you as the chair to write a letter to the Board of Supervisors regarding not meeting without a time frame because the Sunshine Ordinance Task Force is in violation 6730A. But I don't think you need to go into specifics of what you want to input into the motion.
Okay, yeah, and I've taken into account all the public's comments and things of that sort, and definitely will have that as a thought process as I write this letter.
Chair Grant, Todd, sorry, over here. I just want to, I didn't think that we said that we weren't going to meet. I thought that was the whole point of that. We were not going to give a time frame or give them the opportunity to basically shut down the task force. If we said we're not going to meet until we're compliant, it was my understanding that the motion was to write a letter that strongly words that we would like them to put us in compliance, to talk about the 45-day issue, to encourage them to get us to compliance as quickly as possible, but to not kind of say we will not meet again. So I just want to be clear. That was my understanding. We were not going to include that in the letter because then that gives them the option to basically, if they don't appoint someone, then we've just cut off our nose to spite off our face. To cut off that, what I'm saying.
Yeah.
Right. Anyway, so I just want to be, I want to know if, I want to make sure because I will not support a letter that says that we will not meet again.
Got it.
Okay.
And following that point, to insert language in future meetings stating that we know we're not in compliance until this is taken care of, on suggestion of one of the learned members of the public there. I think that's a very good suggestion as well.
Yeah, can you repeat that for me one more time?
Just to put language in our agenda saying that we are not currently in compliance until this happens, and just to kind of cover ourselves.
Exactly. So that was one of my issues. And I won't put that we are not going to meet until then. If by the time that we are scheduling our next meeting, we find ourselves still not in compliance, then I can choose to cancel the meeting until we are in compliance. But I'm not going to put that in the letter to establish. So, okay, can we take a vote for this? And I'd love to have a roll call vote.
Member Nee?
Aye.
Member Nee, aye. Member Monet?
Aye.
Monet, aye. Member Washburn?
Aye.
Member Washburn, aye. Member Pilpel?
Aye.
Member Pilpel, aye. Member Sims?
Aye.
Member Sims, aye. Member David?
Aye.
Member David, aye. Member Highland?
Aye.
Member Highland, aye. Member Fisher?
Aye.
Member Fisher, aye. Member Grant?
Aye.
You have 9 ayes.
Madam Chair,
Yes.
move to adjourn.
Thank you. We're
Second.
meeting adjourned.
No,
No,
hold on.
I'm just wishing. Okay, discussion? Member Pilpel?
So if we adjourn this meeting, then we will take up the 4:35 meeting very quickly and decide how to dispose of that. And then, okay, yes, I'm good.
Any conversation about, is everyone in agreement to adjourn this meeting?
Was there a second?
Seconded.
I seconded that motion.
No more comments? Public comment?
So I think I'm going to have to get a hold of the Board of Supervisors tomorrow and indicate to them that you just took lengthy public testimony on a motion, only to have Mr. David pull the rug out after the public testified on the motion that was on the floor. The motion on the floor was that you were going to include in the letter.
Excuse me, Madam
We were
Chair.
going to, I'm sorry, I'm speaking to the motion to adjourn, but I'm suggesting that before you adjourn, so that I'm not supporting this motion, that you go back and you revisit what you just did. What you just did was Mr. Sims had indicated that it was very clear, there's no ambiguity in it. But what is the purpose of sending them a nice letter that says, would you please do something quick, without telling them that your intent is that if they don't comply by the time of your next meeting, that at the discretion of the chair, you're just going to cancel the meeting? Are you going to convey that to them privately, or should I do that for you? Because after all, members of the public came
Thank
up
you
here
for your
and
comment. I'm sorry.
testified
I'm going to
about
interrupt you, sir. I understand.
that, and then Mr. David pulled the rug out from our
Understood.
testimony.
Understood. We're just going to move on because that has been voted on and second and closed. So we've adjourned this
Well, public comment.
public comment. I'm sorry.
Yes, unfortunately, you're still with public comment. Once again, it's Jason Grant Garza. I've been here 10 years. I've had decisions. I have orders of determination. I have ethics overruling. I have everything. You know, earlier you mentioned the word morality. And the morality is that you're going to adjourn right now because you want to comply with the spirit and the letter of the law. Well, I'm a little confused by that because ethically speaking, knowing morally that everything you've sent up to ethics in the past has always been overruled and will continue to be overruled. Specifically, when I've told you that you guys should step aside until you're granted power. And I did that, I believe, in 2007 to Mr. Nee, and I have the paperwork to prove that. The fact that you're doing this now has confirmed what I said all along, that you're shills for the city. How many people go through the process after they've been morally raped by you guys, issuing an order of determination that ethics kicks down, that never gets resolved, and yet now, because you're not living within your letter of the law, you're not going to meet. Well, when you were harming me and everybody else who came to you expecting justice, and when it got to ethics, the correct thing being done, you didn't step aside as you are now. It's nice to know that the morals have changed. Thank you very much. Have a nice day, and God bless.
Members of the task force, Ray Hartz, Director, San Francisco Open Government, and I take no pleasure in these issues and the position you've been placed in. I think, and I have said to the Board of Supervisors that their actions were unacceptable. That basically what they were so determined to take revenge on the past members of the task force who decided against them in the Park Merced case, that they just didn't really give a damn about the procedures, about the fact that they were violating the ordinance, that they were putting you in this position. And the bottom line is, I sincerely do not believe that unless you give them some sort of a fire under them, they will do anything to resolve this. Very frankly, I think that there are at least two members of the board who I think would take great pleasure in seeing the task force not meet. And that's why Member Monet's comment earlier about putting this out to the press, especially now that it is an election year, is going to be something that will give them a little bit of an impetus to do this. Because really they have no incentive to do it unless there is something that forces them to do it. It's just like some of the comments that have been made about changing the ordinance. They are not going to enforce and change an ordinance to strengthen it when it is them against whom that ordinance will be used. The only way to effectively strengthen the Sunshine Ordinance is to do it the way it was originally done, and that's to make it an initiative of the citizens, where it says we want our elected officials to be responsive, and we don't want them stepping in and sticking their oar in the water and saying, well, we're going to make all these changes so that we can subsequently ignore the law that the citizens passed. This law has been in place since 1999, a change in, 2003? And there are still city agencies who sit out there and go, what's the Sunshine Ordinance? And one of them actually, in a meeting I attended, asked the deputy city attorney, what's the Brown Act? And it's like, you sign a Sunshine Declaration and you don't know what the Sunshine Ordinance is? What the hell happened to that oath you took to protect and defend the Constitution of the United States?
Thank you. Any more comments on adjournment of this meeting?
Do I understand that if you adjourn this meeting, you're going to then reconvene for the second meeting and have an election? Is that correct?
No,
No?
we are going to, but we're not going to have
Okay,
election.
thank
We
you.
had the two agendas, so we have to.
Thank you.
Right, you're welcome.
Peter Warfield, Library Users Association. I am glad that a number of the suggestions that I made earlier are being incorporated in your letter. And I think it's a very sad thing that you're adjourning. There are many cases that are before you, and there are cases that I can certainly tell you haven't even been filed because of this crippling of your ability to function. And not to be able to give the little justice that you unfortunately are, even in the best of times, able to mete out is very sad. By that I mean, as an example, the Arts Commission came and, before your time, some months ago, openly defied the Sunshine Ordinance Task Force with respect to one of the orders of determination that we, library users, got against the Arts Commission. And I see that Member Manet is remembering and nodding her head. So it's bad enough in the best of times. This is a very sad business. And I do think you should make as much of a, as we used to say, stink as possible. And with that, I would say you all have a right as citizens, as members of the public, you don't have to be a citizen even, to go to the Board of Supervisors and make public comment and do so publicly. You don't have to coordinate amongst yourselves. You're certainly allowed to hear it from me and anybody else. 2 o'clock pretty much every Tuesday, and the board is required to take public comment. I think it would be wonderful if 1 or 2 or 3 or 5 or 8 or 10 of you would be there in public, giving them a piece of your mind and telling them how they are letting down the public and themselves violating sunshine. Thank you.
Thank you. There are no more comments I'd like. Are you coming to comment? Yes, about the adjournment of this meeting?
Has this gentleman already commented?
Did you? Not on this
No,
issue.
not on this item.
Okay, sorry.
Yes, I want to say that I approve and appreciate the decision to adjourn, and I just wanted to suggest, since this is an adjournment and since there is a question mark over the next meeting, I would like to humbly suggest that there seems to have been throughout this meeting a lack of clarity, even amongst the task force, as to who is responsible for these appointments, who is beholden to this body and to the public in terms of ensuring that this process goes through. And I would just like to humbly suggest that from now until the next potential meeting time, you guys get your own clarification on those questions, and then perhaps another meeting would be in order, but a special meeting to openly declare to the public if there are any bodies or individuals that are blocking the functioning of the Sunshine Ordinance Task Force, so that we can exercise our rights as citizens or residents in directly going after the people that are blocking open government in San Francisco and raising our power to support you all. That's just a suggestion. Thank you.
Thank you. I'd like to take a vote on this adjournment.
Member Nee?
Aye.
Member Nee, aye. Member Manet?
Aye.
Member Manet, aye. Member Washburn?
Aye.
Member Washburn, aye. Member Pilpel?
Aye.
Member Pilpel, aye. Member Sims?
Aye.
Member Sims, aye. Member David?
Aye.
Member David, aye. Member Highland?
Aye.
Member Fisher?
Aye.
Aye. Member Grant?
Aye.
Grant, aye. You have 9 ayes.
Great. So this meeting is adjourned. So I need to
Call the 4:35 meeting.
Or declare it canceled.
say it again.
I said, or declare it canceled.
And declare it canceled.
Can I declare it, or do I need to make a motion? If I can declare,
you.
then I'd like to
You may
declare the
declare
4:35 meeting canceled.
Bravo. Hold on. You were going to declare the next one.
Let's hear what he said.
Through the chair, I think in the interest of being cautionary about it, you should call the meeting to order and then take a motion to adjourn. I think that would be the best process for it.
I'd like to make a motion that we call the. I'm sorry, I need to call the meeting to order.
Let's call the meeting to order at
6:49.
6:49. Will you take? Do I need to do the roll call again?
Yes.
yes.
Okay. Madam Clerk, will you do the roll call?
For the second agenda for 4:35. Roll call. Member Nee?
Here.
Member Nee present. Member Manet?
Present.
Member Manet present. Member Washburn?
Here.
Member Washburn present. Member Pilpel? Pilpel present. Member Sims.
Present.
Member Sims present. Member David.
Present.
Member David present. Member Highland.
Present.
Member Highland present. Member Fisher.
Present.
Member Fisher present. Member Grant.
Present.
You have a quorum.
Thank you. Yes, Member Nee?
Madam Chair, in light of the fact that we cannot proceed with any business without violating Section 67.30A of the Sunshine Ordinance, I move to adjourn.
Second.
It has been moved and seconded to adjourn the 4:35, the second meeting for today. Is there any discussion amongst the task force?
I don't think it requires a separate motion, but I think implicit in this is that the election starting for July 1 will be continued to the call of the chair and will just happen at the next meeting whenever that happens. So I'm not suggesting that that requires a separate motion, but I think that's implicit in adjourning this meeting.
Yes, everything that was on that agenda, correct? It was one item on that second agenda.
Through the chair, Member Pilpel correctly stated the implication.
Great, thank you. So public comment. Then.
So, Chair Grant.
Yes.
I would advise an abundance of caution when you go to develop your next agenda, because I think Robert's Rules of Orders states that if you're going to rescind a vote from a previous meeting, you have to put notice that you're rescinding a previous vote onto the agenda, such that you're in compliance with the Sunshine Ordinance, which states your agendas have got to be clear to a reader of average intelligence that you're going to rescind a vote that you took on June 6th. So imagine my surprise when I saw that 4:35 agenda, and there was no notice to the public that you were going to reconsider a vote that you had already taken on June 6th, at which I believe Mr. Nee, if my memory serves me, Member Nee, had made a motion to conduct that election prior to July 1 and have it effective for after July 1, and that you were going to conduct a single election to conclude the end of 1 year and for the next year. But if you're now going to strike down that vote that you took on June 6th, you have to tell the members of the public that that's what you intend to do on your next agenda. Furthermore, if you're going to cancel a meeting, please do it early enough that you don't actually get people down here only to have to wade through another let's adjourn. If you're going to exercise discretion of the chair, do it in sufficient time that we don't waste our time coming down to City Hall for nothing.
Thank you for your comments.
Once again, my name is Jason Grant Garza, and a couple of issues I want to bring up about this adjournment, once again brings up the issue. If you go to myownprivateguantanamo.com, there you will see the Nurse Ratchet letter that I received that was supposedly sent up to ethics that was dismissed without anything. This thing to dismiss and send letters to all these agencies that have basically shined you on, not even ruled that your facts and findings are valid, which is what this body sits for, and has completely gutted the Sunshine thing, for you guys to keep adjourning and everything. When I said I made this, the Orange Jude Amendment available to you guys in 2007, and now for this to continue, morally and ethically does not speak right in Sunshine, about Sunshine, and as a matter of fact, you'll read at myownprivateguantanamo.com the responses from ethics and how valueless you are and how nothing has changed. As a matter of fact, there you'll see the Nurse Ratchet letter back from the Sheriff's Department for an immediate disclosure request. And you'll also notice the paperwork from the media that everybody wants you to go to, saying how important this is because, it never gets done correctly, and Mr. Nee's going to correct it in 2002 with the Rules and Compliance Committee, and we're sitting here now in 2012. If it was so important for the media, when they were sending people back in 2002 to cover my Nurse Ratched case. Why hasn't it been so important now? It's another ploy. It's another rigged process. You know, this all comes down to, you know, a good cause and no effect. Oh, we're all running for the March of Dimes. We collected a whole $1, but the administration got 95 cents.
Thank you.
Rigged is as rigged does. Thank you.
Great, thank you. Sir, I think you believe you're the last speaker? Okay. Second to last speaker on the adjournment of the second meeting.
Yes, this is Peter Warfield, Executive Director of Library Users Association. I would first of all like to complain about the late start of this meeting. And as a courtesy to the public who may have come for this issue, because as a matter of fact they might have been puzzled or concerned, particularly with respect to last month's action, it seems to me as a courtesy to the public who's here and to yourselves that there might have been some explanation or some notice of an intention earlier. Certainly others from the public have asked about this part of your evening. Second, I wish you would have taken up item 2 so that there would be on the record an explanation for those who may just see this agenda or minutes, so that folks like that would know, well, it's related to the previous meeting, and it's related to your determination that you did not have the proper complement of members to meet legally and take any action legally. So if it's part of your adjournment, if it's going back first to this item and explaining why that's being done, or if it's just running public comment and indicating that it's my opinion that that's why this has happened, one way or another, I think it's important for the public who may be looking at this a month or a year later, or yourselves. Gee, what happened with that one? Wouldn't hurt to explain what's happening, and certainly wouldn't hurt to let the public know what your intentions are before 2.5 hours or so has gone by. Thanks very much.
Thank you. Mr. Hertz?
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I want to congratulate you because I think you've gotten off to a good start in the sense that if, as I said before, you can't follow the rules yourself, it's going to be really hard for you to bring any city body, commission, agency, employee, whoever in here and say to them, follow the law, because they will throw it back at you. You don't follow it. Why should I? And it will also give them an out, which is, I don't really care what your order of determination was. You didn't follow the law. You weren't in compliance, and the decision you made was not legal. So I can just basically ignore it. And there are enough members of the city attorney's office who would be willing to back them up on that, that putting yourself in a position other than what you have would simply set you on a long, hard road to hoe. Sometimes I mix my metaphors. So again, many of the people who come here with cases before the task force you're going to find are people who are really interested, like myself, in two things. When I go to a board or commission, I always tell them at the first meeting, I'm here for two reasons. One is to make sure that members of the public are allowed to make meaningful public comment. And number two, that they're allowed to have access to public records, which they need in most cases to make those comments. And I think those are the things that that members of boards and commissions take an oath, they pledge allegiance to the flag, and I have to wonder sometimes with the Board of Supervisors when they pledge the allegiance to the flag at the beginning of each of their meetings, whether they really have taken to heart the actual words they're saying or simply mouthing the words. Basically, I'm here not just for my own issues that I raise, but primarily because all the issues I raise have to do with the public's access to meetings, and you're the folks who have to enforce that.
Thank you so much. This time, I'd like to call for a vote, but a voice vote. Can I, do, without objection, to adjourn this meeting? All in favor?
Aye.
Right, meeting adjourned.
Oil thing.